Friends, I just pressed the Let's Go Live button, so let's wait for the stream to fire up all across the fruited plain of the internet. We've got some serious Trump trial business to get to, including calls for a mistrial, but we can't get started until we can make sure everything is alive and well. We had some technical changes around the weekend. We got some new lights. We got new inner tubes, all new cables and new tubes, and so hopefully everything is working well today. We'll cross our fingers, but it looks like we're connected, so that's great. Let's get started. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gouveia. I'm a criminal defense attorney broadcasting from the Valley of the Sun, deep in downtown Phoenix, Arizona, and today we are talking about a mistrial. Woo! Donald Trump and his defense team fired out a doozy of a letter to the federal judge, Judge Kaplan, in day 4 of the Donald Trump trial involving Carroll. So we're going to go into that, but we're going to check in first and foremost with the Proud Boys because there were some jury notes that came out today, and I don't think we're going to be getting to a verdict anytime soon. We'll see. So we're going to go through and do a quick recap of jury note 1, 2, 3, which came in last week, and then we'll check out jury notes 4 and 5, which came out today. And you can see here, this one's a pretty big one, kind of a doozy there. So we'll take a look at what that one entails, of course, in the Proud Boys update. Now, after that, we're going to turn our attention over to the Trump trial because we have a lot to get to here. And you can follow along on this at home if you would like to join. This entire mind map is navigable. You can go to spotlightlawyer.com/Trump. if you want to follow along at home, and you just click these little nodes and things just open up and you can just sort of browse around at your leisure. But today we've got day 4. Carroll, the woman here, is alleging that Donald Trump did a thing to her some time ago. And she, as we wrapped up last week, was in the middle of a cross-examination with Joe Tacopina, Donald Trump's defense lawyer. So we took a weekend break. We start back up with Donald Trump's defense team, cross-examining Carroll. And then there's a redirect exam by her lawyers to try to rehabilitate her and bring her back into the good graces of the jury. Now, there was a doozy of a motion for a mistrial. And we are going to spend some time on this because they also included a partial trial transcript. And we get to read through the transcript and see exactly what is going on there because there was some interesting things happening that we were able to glean out from the live Twitter thread. So we'll go through that. A couple other exhibits. One talking about billionaire Reid Hoffman's LinkedIn post, and another one talking about a Vox article, all part of the request for a mistrial on behalf of Donald Trump. And it's a good one. So we're going to go through that. Actually references a lot of the same critiques that we had of the trial testimony thus far. And as usual, we'll check in with our friend Matthew Russel Lee, who is live tweeting from the scene. And you can find him at innercitypress on Twitter or at innercitypress.com. He does a great job. And he's got all sorts of, you really should follow him if you want to stay plugged in with trials. He does a great job. He does videos. He does these booklets that he publishes. And it's just he's a great person to follow. So if you're into this stuff, make sure you're giving him a check out. Now, we, of course, have a lot to get into. And if you want to be a part of the show, my friends, the best place to do that is by joining as a member in one of our amazing membership communities. The home base is watchingthewatchers.locals.com. We have an amazing community there. No matter where you're a member on YouTube or on Locals, we do member-only morning streams. We had a great one today where we cover some of the other things that there's not enough time to get to here. And so come check it out, watchingthewatchers.locals.com. And I want to pause for a minute and say, holy moly, thank you to our friends Dolphin Fan and Curtis Bartle, who on this lovely Monday invited 25 new people into our membership community. It's just amazing. And so thank you so much for that, Dolphin Fan. And thank you so much for that, Curtis Bartle. I mean, we've got just a whole slew of people. Who's coming in? Gustav, Mark, True Neutral, Mimetic, Captain, Lenny Malley, Lauren, Jim, Angry Viking. Woo! Angry Viking veterans in the house. Dr. No Name, Mike Martin, Rogue, Michael, Carroll, Be Happy, Alexis, Bullwinkle, Sprinkles, Garrett, Alice, Slap Murphy, all gifted memberships courtesy of Dolphin Fan. And our friend Curtis Bartle is bringing in Gate Watchers, Sean Wookie, Nikki's in here, Queeno, and Toenail Cupcake. Woo! Yummy. All over as part of our community. Thank you to Curtis Bartle. Thank you to Dolphin Fan. And welcome to everybody who is coming in as a new member. And our morning member-only chats are getting full. They're getting full. We're having a lot of fun. And I think we went for like an hour and a half this morning. It's good stuff. All right. Also, now I don't want you to forget, because we've got a lot of trial ahead of us. Donald Trump is coming in hot, and there's going to be more prosecutions, more indictments. And so we've got to get ready. We all would like to lose those leftover pandemic pounds, all of us. But how sick are you of the ads for the weight loss pills and the fad diets and all that stuff? We've all been there. We've all done that. We know they don't work. But you know what does? Holy moly. We'll get there in a minute. But you know what does? Eating 5 healthy servings of fruits and vegetables every day. You do that and the weight would probably just fall right off. But vegetables, not a fan. And fruit, who's got time to prepare that every day? Instead, let's talk about Field of Greens. Now, Field of Greens is a science-backed formula of very specific fruits and vegetables that you won't find in any other product. Proper nutrition reboots your metabolism so you can burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you'll look and feel healthier fast, but the greater proof is going to come at your next checkup when your doctor says, wow, whatever you're doing, keep it up. You've lost weight. You look fantastic. So let's get you started. Go on over to fieldofgreens.com. And when you get there, you'll order your real organic superfood. And don't forget to use code Robert when you check out so you can save 15% at checkout. And remember, the vegetables want to be eaten. It really is good. It's important to stay healthy, to stay well, especially when our food is garbage and a lot of the stressors in our environment make our health a little bit troubled. And so Field of Greens, real organic superfood, get your fruits and vitamins and your vegetables. Save 15% with code Robert at checkout. And all right, holy moly. So we got to pause here and say John McGarvey just gifted 50 memberships. 50. It's going to take me 20 minutes to read all the names. John McGarvey. Thank you, John, for doing that. Literally 50 different people. And so we'll save that for the end. But holy moly. All right. So we're going to have to save that. And it's still, I think it's still spitting them out. It's like a casino went off in Vegas, like cha-ching, 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 membership. So thank you to John McGarvey. I mean, tomorrow is going to be lit. And so we'll cut John is a hero, not to 50, blessed. Wow. Yeah. So a lot of people, welcome in to our community. Tomorrow morning, our member only stream is going to be lit. John, thank you so much, John. And John's a member of our locals community too. Yeah. It's like, man, it's like Vegas, man. Somebody, I don't know, play the lottery or something tonight. I don't know. It's crazy. Thank you, John. Very, very, very much appreciated. I think that's extremely generous. 50. Whew. All right. So thank you, John. Let's get to it, my friends, and get queued up and get into the meat and potatoes on the day and get right to it. Whew. All right. We have Proud Boys trial continues with deliberations. The jury has already asked several different questions. We've gone through the notes and their responses. You can see previously they asked the judge, hi, could the government please remind us of the 2 exhibit numbers, the video file from Zachary Real, a defendant, when he was crossing the barricades. Can we get the exhibit number for that one? And also, can we see the video where Biggs, another Proud Boy defendant, suggests they pull their masks up to hide their identities? The judge said, yeah, sure. Here are your 2 exhibits, and you can take a look at them wherever you need to look at them. And that was submitted back to the jury. They also asked a question. They said, hey, we request the following. We want to take a look at the police shield, the Capitol Police riot shield. We also want to look at the Proud Boys megaphone. We'd also like to see the membership chart. And remember that they gave them the riot shield and they gave them the megaphone, but they could not get the chart because that was just a demonstrative exhibit that would not be admissible as evidence. Now, we also saw that they asked for a missing drive. Exhibit 490A is missing from a hard drive. Can we get someone to check our drive and add this to our drive, they say? And Exhibit 490A was a big video file that apparently showed an FBI informant picking up Enrique Tarrio from jail on January 5th before January 6th. They also wanted a stapler. The judge said, yeah, you'll get the exhibit and a stapler. And so there were 2 more notes that came in. And the first one is this one. And you see here, they ask filed on May 1st. It's just a note. It's not even a question. They're just letting the judge know they've got appointments coming up. Juror 0039 has an appointment Monday, May 8th, 1 week from today. They need to leave by 3:30 p.m. Okay. Another juror, totally different number, has an appointment this Friday, 2 p.m., needs to leave by 1:30. 1324's got an appointment on Monday next week. They've got to leave by 3 p.m. They got to leave by 2:30. And so maybe they could carpool with juror 0039. Another 0039, this person's got a lot of appointments. So 039's up here, 039's down here. They need to leave Wednesday again by 1:30. And then another juror says, I can be here by noon. I've got an appointment Tuesday morning, but I can be here by noon. Another one says, I'm out of town all day on Thursday, so I'm just not going to be here. And then another juror says on Friday, I can be here by 10 a.m. And so you go, well, okay, well, I guess the jury is just setting their own schedule, I guess. And this is kind of hysterical because what I think the judge is going to say is, I don't really care about most of these appointments. I mean, unless these are critical, you've got a job to do. You are here in deliberations. This is a critical trial. What are you doing? So I'll be surprised what each one of these is for and whether the judge lets them go to them or not. And I posted on Twitter, I was very happy with myself. I said, how many of these appointments are with the FBI? All of them? Are these at FBI headquarters? Where are they going? So that they can have meetings with them? I don't know. But anyways, they're busy. And so the judge is going to respond to that. Hey, we're busy, man. We're busy. This is a lot of work deliberating. This guy's taking Friday, a couple of them taking Friday off. All right. So we have another jury note that came in, not very substantive, but this one also filed May 1st. It says, please provide the exhibit numbers for the Donahoe water bottle throwing examples. Which is interesting because Donahoe is not an actual Proud Boy. He is, at least he's not a Proud Boy defendant in this case. He's somebody else. So why are they curious about Donahoe throwing water bottles? Remember, one of the charges against the Proud Boys is about a water bottle. It was a violent assault with a water bottle. And they keep saying that these were frozen and that these were violent insurrection water bottles and they were filled with hot lava or something. And when they were throwing these, if they were frozen, filled with toxic whatever, then that would make it more dangerous. But if it's just an empty water bottle and it bounces off some riot shield, is that really an assault, or is that just an errant water bottle flying all over the place? So we have questions about that, and the jury has questions about it too. What are the actual water bottles? What do they look like? And the defense has pointed out that they don't think that there is any evidence that they were full, that they were frozen, or anything like that. And so we don't have much from the Proud Boys. Let's take a quick look and see if there are any new updates since we started the show. Any responses? There is a response. And so here, let's see if we can pull out an update or two from the Proud Boys trial. And I don't think it is even up yet. Okay, so there is a note that has come out, but it looks like the file is not published. Let's see here. The court issued a response to the notes. Let me see if I can just grab this here while we are here. I've got to actually log into the federal court system. I kind of had a feeling this might happen. And I'm kind of glad it did, so we can see what the judge said. And here is... No, that didn't work. All right, I'll dig it up tomorrow. The links are bad. When it's a fresh document and it hits the docket, sometimes it's hard to pull the document. So we'll check that tomorrow. Anyways, the point is, here is the most recent update on the docket. There was a couple jury notes. Jury note 5, we just saw that. The court responded to the jury notes. I don't know if it was a response to the scheduling order or what, but we'll see. It sounds like from what we have seen thus far that they are not even close to coming to a verdict. Why? Because they are asking for scheduling into next week. And you got to imagine if you're in a jury room and you all think they're guilty on everything, you don't need to talk about this stuff. But if you've got a bunch of people who have a lot of disagreements, one of the first things you might try to decipher is what the schedule looks like. We're going to be here for a couple weeks, it feels like. What's your calendar look like? So we'll see what the judge says about it, but all quiet otherwise. Out on the Proud Boys trial front, we will, of course, continue to follow. All right, my friends, now let's turn our attention over to the Trump trial. Now, as I said, if you want to join in and follow along at home on this mind map, you can. It's at spotlightlawyer.com/Trump. And if you go over there, this is what you will see. And so let's do a quick recap on what happened. We are in Trump trial day 4. And you can see we have had several other days of trial. We had jury selection on day 1. On day 2, we had the direct testimony from E. Jean Carroll, along with the store manager from Bergdorf, the department store. On day 3, which we wrapped up last week on Thursday, we had the cross-examination of E. Jean Carroll, which is the plaintiff who is suing Donald Trump, on the stand, and we left off there. And so today, we've got a couple different updates. We've got a full trial thread, but before we get in there, we've got to talk about this motion for a mistrial, because it is a doozy. Donald Trump's defense team demands a mistrial, saying that Judge Kaplan has allowed all sorts of egregious violations to carry on so badly that they justify throwing the whole trial right in the garbage. The letter came out from Tacopina, Donald Trump's defense team. It's 18 pages, filed on May 1st, and it gets sent over to Honorable Lewis Kaplan in the case of Carroll versus Trump. They say, Your Honor, Judge Kaplan, we respectfully submit this letter on behalf of Donald Trump to request that you, this court, grant a mistrial based on the pervasive, unfair, and prejudicial rulings by you, this court. Or in the alternative, correct the record for each and every instance in which the court has mischaracterized the facts of this case to the jury and allow Trump's lawyer to have a greater latitude to cross-examine Ms. Carroll and her witnesses. And we noticed this last week. When we were going through the cross-examination, we were quite surprised that there was so much interjection by this judge. In fact, Joe Tacopina himself said, I'm at a total loss, Your Honor. He was cross-examining her and asking her basic questions, and the judge was saying, hey, move on. We can all do math. We don't need to hear from you. Carry on. What are you doing? And even told him that I've already made my ruling multiple times and carry on. So the defense says a mistrial, Your Honor, should be granted because you, Judge, you mischaracterized the evidence in favor of Carroll. You bolstered the testimony of Carroll, which we talked about. We said it was vouching, saying in that weird exchange that it almost reminded him of another novel. Something. He's like, oh, no, it's very much like a novel that I used to read. Supporting her statement against the defense. Also allowed Carroll to testify that Trump has 2 tables of lawyers at trial while prohibiting the defense from fairly clarifying the record by showing that Carroll has a comparable amount of lawyers. So while she was on the stand, look at that whole team of Trump lawyers, and she's only got 1 or 2 people at her table. Well, in the filings, there's a whole slew of people. They just didn't bring them into court. You also, Judge, continuously sustained improper argumentative objections. We heard those last week. Of plaintiff's counsel as to questions using a well-accepted looping methodology of cross-examination. You also permitted the testimony of Natasha without any voir dire of the witness when it's clear that her testimony does not follow the rules of the evidence and should be excluded. You also alluded to the potential use of United States criminal statutes as a remedy when Donald Trump's son, Eric Trump, posted something. And you remember when the trial started, Trump posted some stuff on Truth that the lawyers brought up to the court's attention. They were very upset about that. And then Eric Trump posted, and the judge said, this might be essentially, without saying it, this might be interference with the trial or obstruction or jury tampering, right? Pick a statute, pick any one of them. The judge was hinting about that. He said that you bringing that up in trial was castigating a completely truthful, and you also didn't allow non-prejudicial statements about Reid Hoffman, the billionaire founder of LinkedIn, who's funding this whole thing. Judge expressed distress with Trump's lawyer for bringing to its attention that someone on the plaintiff, Carroll's side, violated the court's order, which led to the worldwide publication of their jury trial results. Remember that Kaplan and her defense team, they put together a mock jury, and they tested E. Jean Carroll's cases in front of 3 of them, and 2 of the 3 found Trump liable for the allegations, and they leaked that to the press. And they didn't express any concern, the judge, that its protective order was clearly violated. So look at all of these things that have already happened. All of this is on behalf of Judge Kaplan, making decisions, making rulings, and changing the trajectory of this entire case. The defense continues. They said, Your Honor, you clearly mischaracterized the evidence in favor of Carroll with respect to surveillance cameras. You did not allow Trump to question her as to whether she even attempted to ascertain whether there was footage showing the parties together. Was there any camera footage? The Bergdorf Goodman store manager of the woman's store during the relevant time period, Cheryl, testified that, quote, she was certain that they had surveillance cameras at the entrance and the exits of the door. Somebody asked her in this trial, Hey, Cheryl, do you have security cameras? She said, the only thing I can tell you for certain is I know that we had them at all of the doors. So if E. Jean Carroll's story is true, then her interactions with Trump on the ground floor should have been captured on video. And if a video existed, that would have significantly corroborated her story. It is Trump's position that her story is completely false and she knows it. Consequently, proof that Carroll never attempted, never even tried, to determine if the footage exists constitutes circumstantial evidence that her accusation is false. Trump says that if she did not seek the footage of this attack, the reason she didn't go find it is because it never happened. Accordingly, Trump's counsel asked Carroll if she made efforts to retrieve the footage. Miss Carroll, you know there are cameras there, right? I think so. Did you ever try to go get the footage? The court shut down that line of questioning and alluded in front of the jury to the possibility that no such surveillance cameras ever existed, in direct contravention of the store manager who the plaintiff called in to testify against her testimony. When this question came in, it says, when you were allegedly assaulted by Donald Trump on the first floor and on the escalators with Trump, you never thereafter, that day, the next week, you never tried to get the videos that could have existed to support your claim. Mr. Ferreira says, I object to that, Your Honor, to the breadth of the question. Now, the court sustains this, and this is really an objection about, it's kind of like a compound question. It's very overbroad. The next day, the next week, you ever tried to get the videos? And it's like, well, it's really far, you know. And it's a perfect question, I think. But the judge overruled it. Or sustained it, right? They object, sustains it, so that question doesn't come in. And this is going directly to Miss Carroll. Did you ever try to get the footage? We don't want her to answer that question. Objection sustained. Question goes out. So Tacopina goes, what? The breadth? Okay. The breadth of the question? The hell kind of objection is that? Okay. So they come back to the next question is the next day. He comes back. The breadth. So he narrows it up. So he says, okay, I won't ask about next week. Okay, I won't ask about the next ever, right? I won't ask about did you ever or the next day or anything. He says, I'll just ask you about this. Did you go back the next day, not the next month, week, year, to get the video footage if you have a problem with my compound complex question? The court says, sustained, sustained, sustained. It assumes there is such a thing. And Tacopina tells the judge, Your Honor, Miss Carroll just testified, as did the Bergdorf Goodman witness, that on the floor there are security cameras, Your Honor. And the judge said, well, Miss Carroll testified that she guessed. And we have had testimony from the witness who was at Bergdorf at the time, and she said what she said, and we are not going to ask questions based on this kind of statement. Trump's lawyer says, Judge, can I ask this question? He says, I don't know yet. I haven't heard it. The judge, what? He says, I know you don't know it, so I'm going to ask it, and you'll let me know. So the question goes, Ms. Carroll, did you ever attempt to ascertain whether there is any video footage of you and Donald Trump at Bergdorf Goodman? Objection. On what basis? Court says sustained. I sustained the objection to that question within the last 3 minutes. Hey, but what's the reason for it? You object to the breadth of the question, and then he's narrowed the breadth and says, okay, how about the next day? And I assume there is a thing. Okay, but the other department store manager said there's footage, and Carroll testified that she guessed there was footage, and the judge doesn't want to hear about it at all. The court also expressed to the jury that Carroll could not have Trump prosecuted for the attack because private individuals cannot bring criminal charges, which was a wild thing to hear from this judge. He specifically told the jury when E. Jean Carroll was asked, they said, Miss Carroll, did you bring criminal charges? And the judge goes, you can't bring criminal charges. It's a civil case. And you go, duh, judge, it's a prosecutor. But the follow-up question would be, did you go to the police so they could bring charges? However, the line of questioning related to this issue and what the jury clearly would have understood from the questioning was the defendant's position that Carroll could have gone to the police, made an accusation, which would have led to the prosecution of the charges. But she didn't do that because it never occurred. Trump was not trying to confuse the jury by implying that she could file a criminal case. That's not at all what we're arguing, Judge, and the judge knows that. Rather, Trump simply sought to establish that Carroll's comment to Lawrence O'Donnell that she did not go to the police to seek a criminal charge because it would have been disrespectful to women being attacked around the world was a false excuse designed to conceal her real reasons for never bringing the charges, which is the fact it never occurred. Here's what the trial testimony sounded like. The question from Trump's defense to E. Jean Carroll, Ms. Carroll, according to you, you wouldn't bring a criminal charge against Trump because that would be disrespectful to women being attacked by the border and around the world? Is that what you said? Objection. The court says you already asked that question. Trump's lawyer says, I didn't ask that question. I played what she said. I'm asking a question about what she said. And the plaintiff, right, for E. Jean Carroll says, this is not a criminal case, Your Honor. And the judge sustained it. So Trump's team is getting absolutely railroaded here. I don't even know what the objection is, other than, I guess, asked and answered. You already asked that question. I don't know, I didn't. This isn't a criminal case, sustained. So Tacopina comes back. He says, all right, okay. Well, let me ask you this. How would you, now it's not a criminal case, how would you bringing criminal charges be disrespectful to the people at the border? Objection. And the judge says, sustained. He says, all right, that's it, counsel. He says, correct me if I'm wrong, counsel, but I believe in the state of New York, private individuals can't bring criminal charges and probably have not been able to do that in at least a century or two. And so scolding this defense attorney in front of the jury. And the defense attorney knows that, obviously. But he's being scolded in front of the jury. He's trying to bring up the point that Carroll didn't tell the police about it because it never happened. This is a red herring. The judge is using this opportunity to really take advantage of his position of power and scold the defense here. He says, no, they can't. They can't bring charges, but they could go to the police department. And he says, well, that's not what you said, counselor. We've been up and down the mountain on the question of whether she went to the police, so let's move on. He says, we have not been up and down the mountain of what we just heard. Can I just ask one question? He says, move on. That's what we get. Move on. He says, okay, I guess not. So the defense says, importantly, the phrase bringing our charge as opposed to making a report to the police, was used by the defense counsel because Carroll, when interviewed by O'Donnell, discussed that exact phrase in the context of whether she would consider bringing a charge against Donald Trump. So do you see what the judge is trying to do here? It's very sneaky, and it's not appropriate. But the question came in. You said that you can't bringing, right? The question, how would you bringing at any point, bringing. He's saying, counselor, you obviously can't bring a charge. And he says, I know, Judge, but I'm asking her about her statement where she said and was asked a question about consider bringing a charge. It's just mirroring her language. During the O'Donnell interview, clearly both O'Donnell and plaintiff herself understood, as lay persons would understand, that the reference to bringing a charge meant going to the police to file a report. Nobody thinks that that means you go in there and type up a civil complaint. I'm going to sue you when the jurisdiction. It's not that at all. But the judge is, oh, it's very technical and you're being dishonest to the jury. No, he's not. He's using her own language. Non-lawyers customarily use the phrase press charges when referring to going to the police to get a defendant prosecuted. Therefore, the court's hyper-technical interpretation of the phrase bringing a charge was made simply to protect Carroll from further cross-examination, resulting in unfairness to the defense. There was also a Jonathan Swift reference, which is the weird. We looked this up in the middle of the trial. When Trump's defense elicited testimony from E. Jean Carroll that her book contained a reference to all men in this country being sent to Montana, the court, in order to bolster her testimony, chose to essentially testify himself as to why such commentary was satire due to Jonathan Swift's work, quote, a modest proposal. Tacopina is asking Carroll, he says, okay, at one point in your book, Jean, I think you propose we should dispose of all men, something like that. And he's looking at the men on the jury. You want to dispose of all men? So are you a man hater or something? Okay. And let's see what happens. She said, into Montana. He says, into Montana? She says, yeah, and retrain them. Okay, so you want to, retrain. So all the men here in this courtroom, all the men in this country, all get shuffled off to Montana and all get retrained? She says, you understand that that was said as satire. He says, okay. And the judge says, yeah, Tacopina, it comes from Jonathan Swift's A Modest Proposal 700 years ago, right? And Carroll says, yes, it does, Judge. Very good. And they're playing this little game of patty cake in front of the jury. Totally inappropriate. So he says, let's move on. So the point of what happened with Tacopina about her wanting to emasculate and retrain all of the men is obliterated because the authority of the judge comes in and says, yeah, it's just like Jonathan Swift, A Modest Proposal 700 years ago, idiot defense lawyer. Right? Right, Miss Carroll? Is that true? She says, yes, it is, Judge. Okay, let's move on, Mr. Tacopina. He says, thank you, Your Honor. It's unbelievable. It's not even the appearance of impropriety. After Carroll testified that the above referenced notion of disposing and retraining of all men was satire, the court interjected in a manner that corroborated the testimony by stating such a notion was derived from Swift's book or poem or whatever. Rather than addressing the subject of men, Swift's proposal was to solve a problem of Irish poverty by killing and eating Irish children. That's what the book says, published in 1729. Solve the problem of Irish poverty by killing and eating Irish children. Isn't Joe Biden Irish? That said, if plaintiff wished to elicit testimony about a 300-year-old book that did not address the subject matter of her own book, she could have done so on redirect. Meaning her lawyers could have come up here and talked about that. It was inappropriate for the judge to do so. It was not for the court to provide evidence from the bench to corroborate her testimony in a way that suggested favoritism to one party. Trump's defense continues saying, Your Honor, also, During the defense counsel's cross-examination of Beal, who was the department store clerk or department store manager, I believe, and she testified, I think that was on day one. We don't have any idea exactly who she is, but Cheryl L.B. Beal, the department store manager, I think she was the first witness before E. Jean Carroll came out, says that during the cross-examination of her, the court further bolstered their position, saying to the jury that there was no one on the 6th floor at the time of the attack. Cross-examination back over to Cheryl. Says, here's my question, Cheryl. Given the proximity from the fitting room to the main area, if somebody, let's say, screamed inside the dressing room, would you be able to hear them from the main area? She said, well, if they screamed, I guess, yeah. I mean, depending on the volume, sure, we could hear it. The defense says, and if somebody's head was, and the judge cuts him off. Counselor, if a tree falls in the forest and there was no one there to hear, right? It depends on whether somebody is there, doesn't it? Mr. Brandt says, I got an answer, Your Honor. He says, I know you did, but let's not play this kind of game here. He says, I'm not playing a game, Your Honor. I'm trying to ask the witness questions. He says, you know where I'm coming from. We're all going, what are you talking about? No, we don't. Trump's defense continues. Whether the 6th floor of a popular New York department store was empty of all human presence at the time of the attack is a key issue, Your Honor. Thus, it was proper for Trump's defense to ask her about whether a scream emanating from the dressing room of the lingerie department could be heard. Carroll herself testified on direct that her laughter and her head hitting the wall was loud enough for persons nearby to hear. Question to her. Do you think, based on what you were experiencing in that room, do you believe that if someone had been nearby, they would have been able to hear what was going on in that room? She says, yeah, they would have heard the head hitting and definitely would have heard me laughing. Given these circumstances, the court's harsh admonishment of counsel for asking these questions was improper. As an initial point, opposing counsel did not even object to defense counsel's questioning. They don't care. The judge is objecting for E. Jean Carroll. Additionally, the jury could readily construe the court's commentary as a tree falling in the forest, as its view that no one was present. The jury could just say, yeah, nobody was there. That's why nobody heard her, because the judge told us nobody's there. And lastly, to the extent the court had any concern with the phraseology of a question posed, unjustifiably accusing the defense counsel of playing, quote, games in front of the jury, completely unfair. The court doing so again suggested favoritism of one party over another, all happening right in front of the jury. There was another comment about the amount of attorneys at the counsel's tables. The court, Judge Kaplan, also allowed Carroll to testify that Trump has 2 tables of lawyers at trial. And then the defense wanted to clarify that by showing that the record has on file a comparable amount of lawyers for Ms. Carroll. And so the line of questioning goes like this. But one of the reasons Carroll Martin told you, Jean, right, not to tell the story to anyone, one of the reasons you've testified that you never told the story because of Donald Trump's power, is that right? She said, yeah, I was afraid Donald Trump would retaliate, which is exactly what he did. That's one of my biggest fears came absolutely true. He says, okay. She's getting hysterical. He just lets her go. She says, he has 2 tables full of lawyers here today. It came absolutely true. Tacopina says, okay, Miss Carroll, we have the same amount of lawyers. Not everyone is a lawyer at the table, Miss Carroll, but regardless of that. And the court says, come on, Mr. Tacopina, let's move along here. Let's move along. He says, okay, yes, sir. I guess it's your courtroom. I guess we'll just move on. Now, the testimony about Trump having 2 tables full of lawyers conveyed to the jury the wrongful impression that she is disadvantaged in these legal proceedings. Couldn't be further from the truth. Testimony about Trump's lawyers is irrelevant and prejudicial. It risks evoking unwarranted sympathy to the plaintiff from the jury. But when the defense counsel tried to minimize that prejudice, the court interjected and expressed its dissatisfaction with that effort. Therefore, the court inequitably conveyed to the jury an endorsement of Carroll's view. There was an entire segment where Joe Tacopina was cross-examining E. Jean Carroll, and Carroll and her plaintiff's attorneys were objecting repeatedly, calling it argumentative. And we were having a difficult time parsing out exactly what the argumentative question was because we were reading a live thread, which we'll get to. But some felt argumentative and some didn't feel argumentative, but it's hard to understand because we can't read the full question and we can't see the full question really in the context of the entire chapter. And oftentimes we talk about direct and cross exams as a chapter. And so one question at the beginning of a chapter might feel argumentative, but it's going to be closed when you come back to the end of the chapter. So let's see how they talk about this and explain this. They say, by the way, Your Honor, and by way of continuously sustaining improper argumentative objections, the court has prohibited Donald Trump's lawyers from establishing a well-accepted method of cross-examination known as looping. This concept is based on evidence on the record, while argumentative questions are not. Once you get an affirmation of a fact or phrase contained in your leading question, the new fact can then be reinforced by the rhetorical device of looping. The new fact is used in the next question without re-asking the fact. By attaching the looped fact to a safe fact in the next question, while the who, what, when, and where is still important in the depot, these words should seldom be used during the cross-examination at trial. So he's saying looping is a tool, and he says, in this regard, it should be noted that Trump has a right to cross-examine. Here are some examples. The question to E. Jean Carroll from Trump's lawyers was, Ms. Carroll, it's your sworn testimony that Donald Trump waved at you across traffic, even though he met you only briefly at a party 8 or 9 years earlier and hadn't had any interactions with you since, correct? Objection. Sustained argumentative. Okay, Ms. Carroll, according to you, after Donald Trump saw you through a door, stopped you, supposedly recognized you after speaking to you for a few minutes 8 or 9 years earlier, he then asked you to help buy a present? Objection, argumentative, Your Honor. Sustained, rephrase. So do you see what he's talking about with this looping? He's bringing in the prior fact, which is Donald Trump saw you, stopped you, recognized you, spoke to you for 8 minutes, and then he asked you to help buy a present? Sustained, rephrase. The court made the same objection multiple times. Sustained, he said it's argumentative, it's repetitive, and it's inappropriate. So he said, so to be clear, Ms. Carroll, it's your testimony that even though at the time she wasn't your closest friend, you never confided anything like this before, you thought your first call when you left Bergdorf would be to her? Again, objection, argumentative. Saying the judge should not have allowed those objections to be sustained. There was another segment here about Natasha Stoyanov's testimony. The preceding illustrations demonstrate the unfairness to Trump that has plagued these proceedings. One of the most glaring is the unfairness of the court's willingness to admit the unduly prejudicial testimony of this woman, Natasha Stoyanov. As Trump presented to the court, Stoyanov told Carroll in an interview conducted and recorded by Carroll that Trump, during the alleged Mar-a-Lago incident of 2005, 10 years after the incident, never attempted to touch her genitals or anus, which is required under the rules. And here, even E. Jean Carroll never disputed those facts. Stoyanov told Carroll that Trump, during another incident, 10 years after the incident, never touched her. And so therefore, Stoyanov's testimony amounts to extraordinarily prejudicial propensity evidence. Yet in order to support its admission, The court improperly resorted to bootstrapping other prejudicial propensity evidence. A lot of stuff here. Saying there's another, so basically they're trying to stack in all of these things unrelated to E. Jean Carroll's case. We're talking about the Access Hollywood recording. We're talking about Stoyanov testifying that Trump kissed her, which is not enough to get it in. Propensity evidence is this evidence that says that that if you did it before, you're kind of likely to do it again, right? You have the propensity to do a thing, therefore you did it here. The fact that the court in the first place needed to engage in bootstrapping to admit this testimony highlights this testimony's lack of probative value. They did not even conduct a brief voir dire of her before admitting it. They say here they're also alluding to extrajudicial remedies. Remember when Donald Trump and his son put out a tweet before the trial? They were talking specifically about Reid Hoffman funding the litigation. Initially, it was posted on the tweet. Hoffman admitted to funding this lawsuit. He posted on LinkedIn. He said, in addition to E. Jean Carroll, grantees I have supported include the following people. So it's not a secret. Everybody's talking about it publicly. It's also not disputed that Hoffman has no direct involvement in the case. He is launching a number of efforts to boycott Trump and to stop him from gaining the White House. Therefore, Your Honor, there is nothing wrong with Eric Trump posting whatever he wants. Nonetheless, the court issued some threats. He said, I said something this morning about your client, perhaps now sailing in harm's way, conceivably with his son, if the report I heard is just true. That came out from the judge. Your client, Trump, and his son might be in trouble. Remedies might be available from this court may not be the only relevant remedies. If I were in your shoes, I'd be having a conversation with the client saying, Trump, I'm going to refer this over to the DOJ. And this is going to be in their purview. And if they want to add another prosecution, they can do it. Eric Trump isn't before me. He says, I'm simply suggesting to you, lawyer, that there are some relevant statutes here. Now, although the court didn't identify those statutes, the notion that any statutes would be appropriate to impose a remedy for a tweet is highly inappropriate and incendiary. Eric Trump is free to post what he wants. Consequently, the court's comments in this regard reflect a predisposition, which is the unfair treatment of Trump. Now, there were other situations where the court was scolding the defense. The court has already accused the defense counsel of, quote, playing games in front of the jury, said that to the defense in front of them, based on a line of proper questioning. It expressed no concern about how somebody from Carroll's side violated the court's protective order to leak data to the press. Tacopina told the judge, Your Honor, the jury's been instructed not to read the media, so we can assume the jury's not going to violate the order. But he says, first of all, let's put things in context here. A week ago, right, so the jury's not going to violate the order, so they're not going to see Trump's posts, right? They're not going to read anything about this case, Judge. So just relax. Trump can post whatever he wants. Jury's not reading anything. They're following your orders, right? Okay. Says, but I will talk to him. A week ago, before this trial started, there was an article which I read yesterday in reference to a leak. Not from Ms. Kaplan or her office, of course, but somebody leaked that 2 mock jury trials have come to a conclusion finding liability. Now, you talk about prejudicial before a week before trial. I think that's pretty much the pinnacle of prejudice. The judge says, but you say you're not accusing the plaintiff's team of having done that. He's, no, I'm not accusing her specifically or any of the lawyers on that team, but somebody from their side did it. Whether it was a jury consultant or one of the jurors, I don't know. But somebody from that side leaked it. It wasn't us. I'm being consistent with the court's desires here, Your Honor, and I've got a great deal of respect for Ms. Kaplan, and I like Ms. Kaplan. I'm not suggesting that she would have done that, but someone from that world over there, they leaked it. The judge said someone from that world may have been somebody that was picked up off the street and offered whatever they offered these days to sit for a day and leave. Now, you know how those things work, and you're trying to pin it on the plaintiff. He says, no, I'm not, Your Honor. It's impossible that they knew about other juries and other juries. It was not a person that was on the jury who didn't sign a protective order, by the way, and just left. This individual, if you read the article which I just read, he says, I read it too. It says that there were 37. If I have the number right, people brought in, and 37 were all. In one place at one time, they were divided into 3 groups. He says, yeah. Every person in there knew they were in 3 groups. He says, yeah, but every person, if they were provided 3 groups, would have known what the other jurors came to as a conclusion, I was imagined. Hopefully that was protected, right? The court says, Mr. Tacopina, I have a good imagination too, and I can imagine you're right, and I can imagine that facts are entirely different. So as set forth, instead of saying a single word to the plaintiff's team for violating the order, he challenged the counsel. He says, are you just making this stuff up? I have a good imagination too, just like yours. The circumstance speaks volumes about the court's treatment. So they're asking for some relief here. They're saying, while the defendant recognizes the court has discretion with respect to evidentiary matters, there comes a point, Your Honor, where the cumulative effect of your one-sided rulings manifests a deeper leaning towards one party over another, meaning you're biased against Trump. Moreover, such a finding is buttressed when the court openly expresses favoritism in its remarks. Here, despite the fact that trial has been underway for only 2 days, the proceedings are replete with numerous examples of unfair treatment. Therefore, Trump requests a mistrial. The relief is only appropriate where there's a manifest necessity for the order, and there is here. In the alternative, in an effort to salvage these proceedings and level the landscape, we respectfully request the court correct the record in every one of those instances outlined above. And if this trial does proceed, we ask the court allow defense counsel greater latitude to do our jobs. In a similar vein, so as to enable Trump to fairly defend against these accusations, defense counsel should be permitted to cross-examine her about third-party litigation funding now that she's opened the door on her direct examination. There was another case, however, following a court decision in another case, plaintiff testified at trial about a Democratic operative. The question for Carroll was, what did you sue Trump for? She said, defamation. Why? Well, because he called me a liar. Because he said that I had accused other men of attacking me. He said I was an operative or in a conspiracy with the Democratic Party. He said I was trying to sell a book, so I made up the story. And he said I was too ugly to attack. So I sued him. Another question was, how is Donald Trump different than Les Moonves? She says, well, because Les Moonves was another man who allegedly attacked her. Why aren't you suing him? Well, here, Donald Trump called me a liar. Is that it? Or is it because you guys on this side of the aisle, the Reid Hoffmans, the George Conways, all of the people who are instituting lawfare against their political opponents, they like this plaintiff because she can go after Trump. Les Moonves can't. He's not running for president. She said Donald Trump called me a liar, said I was pulling a scam, said I was a con, I was running a con, that I was a Democratic operative, that I'd accused other men of attacking me, that I was in it for the money, that I was in it for the attention, and Les Moonves stayed quiet. That's why he avoided her wrath. Okay. Now, given that plaintiff, E. Jean Carroll, through her direct testimony, has affirmatively accused Trump in this case of defaming her for being a Democratic operative, she has now opened the door to the litigation funding. She's being funded by Reid Hoffman, a Democratic operative. Consequently, in order to defend himself against the accusation, Trump should be allowed to ask her about this during cross-examination because she brought it up. You say you're not a Democratic operative? Maybe we'd like to present some evidence about that. Therefore, Joe Tacopina says, based on the reasons above, the defense respectfully requests the court grant a mistrial in this case, or in the alternative, correct the record for every instance and allow defense counsel to cross-examine E. Jean Carroll and do their job. We thank the court for its consideration. Respectfully submitted, Joseph Tacopina, going directly to Judge Kaplan. And as you saw here in this beautiful document, they've articulated all of the various injustices that we have observed and covered here as we have been following this trial along. The judge is not going to like this. He's going to think to himself, everything I've done is perfectly legal and appropriate. I'm a judge. I've been doing this for decades now. And who are these people to tell me what to do differently? And so, of course, we'll see how this unfolds in trial and whether Trump succeeds. Speaking of the trial, let's get to it now. Now we are fast forwarding through the timeline and we land on the trial thread, courtesy of our friend Matthew Russel Lee. And he's over at innercitypress.com. And so we'll get this queued up here and get right into it. Trump trial, day 4, E. Jean Carroll still on the stand, going to be closing out cross-examination. As usual, checking in on the live tweet thread with our friend at innercitypress on Twitter. He's also on Patreon and does great work covering this trial with vlogs and other articles and things that he shares. I highly encourage you to follow him at innercitypress. But he is there, and he says that this morning, bright and early, Judge Kaplan comes out and says, oh, interesting. The motion I found on my desk this morning from the defense, has that now been filed? That's the motion, the letter from Joe Tacopina saying this judge has been egregiously violating norms in this case. The defense says, yes, that was our motion. He says, well, I'll take a look at it later. We're getting started today. We're not declaring a mistrial now. Yeah, right. Bring in the jury. Jury enters, all rise. Now he says, okay, Miss Carroll, you're still under oath. You understand that? She says, yeah. Proceed. Joe Tacopina comes back up. Hello, Miss Carroll. Happy Monday. Welcome back. Yeah, she says. Miss Carroll, I want to pick back up where we left off on Thursday. And we were talking about you shopping at Bergdorf's where this alleged attack happened. You remember that? Yeah. It was after the 1995 or the 1996 attack. Yeah. And you continued to shop there even after you were attacked? Yes. Did you go into the dressing rooms when you shopped there again? I don't believe so. Now, Tacopina says, Miss Carroll, I want to refer to your deposition from earlier this year. January 31st, do you remember that depo? She says, yeah. Now, you said in that deposition that you would go into the changing room. Do you remember saying that? He plays it. She said, yeah, I think I was thinking about my niece. It was all a changing room. The niece. Since 1995 or 1996, you've made many purchases from Bergdorf's. Is that true, Carroll? Well, not necessarily many, but I made several purchases. I'm going to pull up an exhibit here and want to show you this. Is this your document, Miss Carroll? Yeah, that's a QuickBooks document from my sister, Candy. And on this document, which is exhibits, you see that there are 4 purchases on here. They all say Bergdorf's. Yeah. She says, yeah. So it's fair to say that you were not afraid of going to Bergdorf's. Is that fair? She says, correct. And you said you brought your niece into the fitting room, and at your niece's fitting, you had champagne with Lisa? Is that true? So it must be a QuickBooks note that says champagne with Lisa. Oh, so when you were there in the fitting room with your niece and also did champagne with Lisa, that sounds like a nice trip. And Burnback, the only person you told about the attack, and you never thought about it? She says, well, a vision may have streaked through my brain. You know, this was a happy occasion. I was there to remember the time. I wasn't there to remember the time in the dressing room in 1996. Okay, but did you talk about that with your friend Lisa? No. Miss Carroll, you remember the show called The Apprentice, don't you? Yeah. You were a fan of that show? Yeah, I was pretty impressed. What'd you like about it? Well, it had ambitious young people. They were all competing on the show. That's kind of what I liked. I didn't like him firing people, though, which was kind of the whole show. Hello. But Tacopina says, Miss Carroll, you posted online that you were a big fan. She said, well, yeah, I said that because 2 of my friends were on there. Hey, but you posted on Facebook here. I'm looking at it right now. This Facebook post says, question, would you have sex with Donald Trump for $17,000 if he couldn't speak? Interesting Facebook post. Would you have sex with Trump for 17 grand if he couldn't speak? Miss Carroll, you joked about this on Facebook, is that right? Yes. So you joked about having sex with Trump 5 years before you were attacked, allegedly. And the judge chimes in. Hey, Tacopina, we all know the math. Don't do the math, okay? Sorry, Judge, I know. Okay. Let you do the math in your courtroom. All right. Says, okay, Miss Carroll, your book that we have written here, it's a list of hideous men. Is that what I'm looking at here, this book here? She says, yes, it is a dark satire, which is fun. Anytime you produce something that's awful, nobody likes it, just call it dark satire. You can let your darkest things out there and just call it dark satire. Fun. He says, well, according to you, Carroll, it doesn't even include all the men you say assaulted you. There's like a longer list than this book of all the people who assaulted you. Carroll's lawyer freaks out. Objection! The judge is freaking out too. He says, members of the jury, please go into the jury room. I've got to scold some people here. So he sends them out after the question comes in. So you wrote a book about all the hideous men in the world. And you've also talked about, as we heard about in prior testimony, men should be relocated to Montana and re-educated and retrained. And this list doesn't even include all of the men you say assaulted you. There's a whole list of other people, more than we've already heard about in this trial. Your ex-husband, John Johnson, violent attack. You also said Les Moonves attacked you. Donald Trump attacked you. Okay. So he sends the jury out. Mr. Ferreira, what's your objection about? He says, Your Honor, this is the lawyer for Carroll. Your Honor, we've briefed the course about sexual prior experiences. The question could elicit that. And it's not appropriate for the jury to know of assaults outside of this book, even some in the book. And Tacopina says, well, I was asking about the book. Okay, the book is public. I wasn't asking about outside the book. I'm asking about inside the book, which she published. He says she testified to the 21 most hideous men. It seemingly does not include all of those who apparently assaulted her. I can tell you the next questions. And the judge says, I don't want to hear your next question. I want to hear your argument. He says it doesn't violate the rules. Her book was in the direct examination. She was asked about her direct, and I can ask her in cross. The judge says, well, there are cases saying that non-consensual sex is covered by the rules. So why would an answer to this question be permissible? He says, okay, I guess I'll withdraw the question. Carroll's lawyer says the book as a whole is not in. The attacks by JJ and Moonves are in, but the whole book is not. JJ is John Johnson, her ex, who apparently strangled her after she called him a very racist name, who strangled her. And judge says, okay, well, if you're not asking the question, then bring the jury back. Jury comes back in and he plays the deposition now. She's talking. We don't know what's in there. The deposition is played, but the follow-up question comes. Miss Carroll, did you report any of these assaults to the police? No. You didn't call the police? She says, no. I was a member of the silent generation. I only called once. I was staying in a farmhouse and kids hit Helen Hayes' mailbox. I called the police because I thought they were marring it. That was my only call to the police. I was staying in a farmhouse and kids hit Helen Hayes' mailbox, which is just a rude thing to do. Poor Helen. So she called the police because some kids threw some rocks at a mailbox, but not an attack in a dressing room. Interesting. Her only call to the police. Tacopina says, so you would, there's the next question. So you would call the police about a mailbox, but not about being attacked? I would not call about something I was ashamed of. He says, strike that as non-responsive. I would not call about something I was ashamed of. He says, that's not what I asked you. And she said, and the lawyer says, well, it does provide context. Ms. Carroll, but in your column, you advised readers to call the police, right? You said, you wrote to other people, call the police, didn't you? Yes? Yes. Let's go through some of the snippets. You wrote this piece. It looks like Ask E. Jean Carroll, May 1994. Is that around the same time you said this happened? Yeah. You advised a reader here. In fact, you gave the New York attack hotline number. It's right here, isn't it? Did you do that? I always advise that. Here's another advice column. E. Jean. This one came out from August of 2006. You recall that one? Yeah. Carroll's lawyer says nothing on the exhibit suggests a date. And Tacopina says, well, highlight that section over there. And Carroll says it's an undated document, so you don't get to put a date on it. And the judge says it's cumulative anyways and move on. So the judge doesn't even allow it. Doesn't even allow it. It's cumulative. Okay. He wants to ask her about another example. August 2006, undated, move on. He says, okay, well, this one has a date in 2016. Do you recall this one, Carroll? Yeah. And you advised to call the police, right? In this column due to threatening emails. Somebody was sending threatening emails. You said, call the police. You remember that? Yeah. And we have another one, May of 2017. We have another example of this, right? And now the plaintiff's counsel, objection, this is cumulative. The judge, of course, grants it. But that same benefit is not applied the other direction. Tacopina says, okay, fine. I got 4 of them, talked about 4 of them. We'll move on. You say Donald Trump accused you of lying about attacking you, right? He lied. He said that you were making that claim to increase book sales, right? And to carry out a political agenda, right? Yeah. And you claim that all of that's false? Yeah. But the story was in the book, though, wasn't it? To market it? And she says, well, at age 76, I was no longer going to be silent. Said, I don't like Donald Trump, and I thought he was a terrible president. Okay. Okay. Carroll Martin, says Tacopina. She asked if she could be reimbursed from travel from New Jersey to New York. She says, yeah. Now, I'm going to show you an exhibit marked as BS. Courtroom laughs. BS, you know. Tacopina says, okay, so this exhibit is up. Shortly after that, Miss Carroll, you replied in sum and substance that you would have that taken care of, right? You told this woman you'd have that paid for. Carroll Martin, her flight would be reimbursed. Remember that? She said, I had no idea how it would be taken care of, but I wanted to assure her she was worried about the cost of bridges and parking. You know, she's on a fixed income. I believe they had a Zoom meeting, you know, so there were no costs about any of it. And so Tacopina says, well, and then Carroll Martin told you that no more chats or no more texts. Objection, not in evidence. And Tacopina says, yeah, but it goes to state of mind. There's a response here. The judge says, let me see it. He says, Your Honor, here it is. The emoji doesn't show up on the printout. If you see it. And the judge says, never assume that I know about things like that. I don't think this comes in. Objection sustained. So that's not coming in either. They ask another question. Hey, Miss Carroll, was your friend Carroll Martin's counsel Noam Bialy? Objection. Another one sustained. Miss Carroll, you know Mr. George Conway? George Conway is the former spouse of Kellyanne Conway. And he was the person, many people say, met with Molly Jong at a party, probably a TDS lib party. And they had a conversation about bringing in a useful plaintiff to go in and stop Donald Trump. And so my understanding is George Conway made the referral over to Roberta Kaplan, and the whole thing was funded by Reid Hoffman, or at least supported by Reid Hoffman. And that is the makeup of this team. And just like, you know, personal injury lawyers or other lawyers will advertise on the radio or on the TV commercials. You have mesothelioma, call us. Same type of thing. They're looking for good plaintiffs to go get big verdicts and victories. E. Jean Carroll's doing the same thing. And so we have questions about where all the money came from and who was involved. George Conway, major anti-Trumper. We know him from the last half decade. And he is now in this trial. We continue. Mr. Tacopina says, Mr. George Conway said that you should seriously think about suing Trump. Is that right? She says, no. He said, okay, well, let me read you from your deposition. I have it right here. You said something like, I had a conversation with an actual lawyer who said you should think about it. Remember that? She says, yeah. He explained it to me the two ways. And you're aware now of Mr. Conway's view of Donald Trump? Yeah. And he recommended you to an attorney who you met 2 days later. Is that true? Yeah. And you met with Carroll and Lisa with this attorney? She says, yeah, we had dinner together. It wasn't an official meeting. But it's your testimony, Carroll, that you chose to sue Trump because he called you a liar. Is that right? He did more than that, she said. Well, I'm going to play a little bit more from your deposition. And in the deposition, Carroll said, he called me a liar and I couldn't get it stand. Tacopina says, Carroll, in your book, you also say that Les Moonves of CBS assaulted you. Is that right? Yeah. And he's on your most hideous men list. Is that true? Yeah. And you accuse him of going after you like an octopus while having an erection. Is that what you said? She said, I wrote octopus, but not erection. No, you're right. You didn't say that. You wrote that he was pricking. Is that what you said? Yeah. Going after you like an octopus pricking. So we're going to use that phrase. We're going to use the erection word, but okay. And you say that Les Moonves denied it? Denied it to New York Magazine. Yeah, he said it never happened. And didn't he call you a liar too? No, he just denied it. He didn't grind my face into the mud like Donald Trump did. Yeah, but you didn't sue Les Moonves. The judge says, this certainly sounds repetitious, Tacopina. You've asked this before, and I don't like where this is going. Cutting him off again. And notice that as far as we can tell, the plaintiff's team is not even objecting, okay? Carroll's lawyers are not even standing in for her. The judge is doing it. They don't have to do it. They can just sit there. The judge is allowing this to move on. That sounds repetitious. They were objecting pretty hard previously, but the judge is interjecting. Here's another one, right? All these are being sustained. Now, Tacopina continues. If Donald Trump had said it was consensual, you wouldn't have viewed it as him calling you a liar? Then would that change the thing? Objection calls for speculation. He says, all right, well, let me play some more deposition. From the deposition, the question to Miss Carroll. Hey, E. Jean Carroll, if Donald Trump said that it was consensual, your time together in a dressing room, then he wouldn't be calling you a liar, right? Right. If he said it was consensual, he wouldn't be calling you a liar. Right. And Carroll's counsel says, we need 7 more lines under the rules of completeness, so they're going to add it all in. And I think this is sustained, meaning this is not coming in. She says, at age 80, I expect nothing. At 80, I expect nothing. So we have something, I don't know exactly what happened here. So I think it might be an objection that the rule, that it's not fully complete. And so the judge is sustaining it, keeping that line of questioning out about the consensuality. So they say, Carroll says, at least it would have been Donald Trump admitting that he was there. Tacopina says, all right, I think this is probably a good time for our morning break, Your Honor. And the judge says, yeah, all right, 15 minutes. And then we'll come back. And so they take a quick 15-minute break, and we fast forward right through it. Judge Kaplan says, all right, what other evidentiary treats do we have in store here today, Mr. Tacopina? He says, well, we seek to introduce this for Miss Carroll's state of mind, not that of Natasha. He says, well, I wish I had a hard copy. We could have a record. He says, well, here's an exhibit, Your Honor. Judge says, what's on the screen is just a subset. What you have up here is the entirety of page 21. This isn't put together. He says, I'll read it to you. He says, it ends on page 31. No, on page 23. The judge says, okay, look, Tacopina, I understand what you're trying to do. Miss Carroll asked Miss Stoyanov if Donald Trump rubbed his body against her. You're trying to say that Miss Carroll was trying to suggest that Miss Stoyanov, quote unquote, remembers the event. At 21, I don't recall. On the next offered page, she got, I don't think so. He says, okay, you can do this in 5 minutes. Let's get the jury. So they bring the jury back in. Judge Kaplan says, sorry, ladies and gentlemen, for the longer than expected interruption. I think we've solved a couple things that will save some time. We are on or ahead of schedule. Mr. Tacopina, it's yours. Please proceed. He says, okay, Miss Carroll, you were assaulted several times, but you only sued Trump. Is that fair? Yes. The judge interjects again. Ladies and gentlemen of the jury, there are 2 lawsuits, just so you're aware. The first was brought solely for defamation. At that time, Miss Carroll could not sue him for the attack, but New York changed the law. And so she now sued on that and the new case of defamation. She says, tells the jurors, don't worry about the first case. All right, let's go. Miss Carroll, you asked Miss Stoyanov if Mr. Trump grinded on you. And she said, I don't recall. Objection sustained. After getting that response, you objection sustained. Okay, says Tacopina. Now, after your book excerpt, Miss Carroll, you were contacted by Anderson Cooper, right? And you appeared on CNN. You remember that? She says, yeah. I'm going to play an 8-minute clip for you. Now, this clip has been taken down and deleted, apparently. Available on YouTube, edited in some places. I do believe we also have this clip here, which is on our mind map, which you can access at spotlightlawyer.com/Trump. You can navigate this entire thing if you'd like. And there are all the other Trump prosecutions. This is the New York Trump prosecution. These are the others that we are investigating, Georgia, special counsel, and others. And so you can navigate this, spotlightlawyer.com/Trump. I love this mind map tool. You can sign up for a free account and use it yourself. However, you can attach videos, and this is one of the videos that we have saved.
You don't feel like a victim?
I was not thrown on the ground and ravished. Which, the word rape carries so many sexual connotations. This was not sexual. It hurt. It just, you know.
But I think most people think of rape as it is a violent assault. It is not.
I think most people think of rape as being sexy.
Let's take a short break.
Think of the fantasies.
We're going to take a quick break. If you can stick around, we'll talk more on the other side.
You're fascinating to talk to.
Yeah. She's pretty fascinating herself. Okay. So that is the clip, right? And it's a much longer clip of 8 minutes. And so if you want to go watch the full thing, make sure you're going to check out innercitypress. He has the full thing right there. And I just liked it. So you can find it in my likes on Twitter. Now, he continues. Carroll is saying, Game of Thrones. Rape is everywhere in the world. Now, Tacopina continues. All right. Now, let's play page 203, line 19, 204, line 7. Deposition. Question to Carroll says, I think Anderson Cooper wanted to get away from the statement that R is characterized as sexy. Yeah, that's why he wanted to cut to commercial immediately. Tacopina says, yeah, but you said you could dine out on this story forever in that interview. Dine out on this story forever. What did you mean by that? She said, well, it was such a New York story. And in 2019, then you sued Donald Trump, right? Yeah. And then you started a Substack. Is that true? Yeah. And you make $70,000 a year from your Substack? She says, yeah. And that's pretty successful for a Substack blog, right? Yeah, it is. That's good. Yeah, that's good. Here, and that's successful, right? Yeah. Carroll says, yeah, I'm now making on audio. They play some audio. Yeah, I'm now making more on Substack than I did before. So long, Elle. She's leaving her company. And you make more money because people subscribe, right? And your life has been pretty fabulous since this happened, Carroll? I'd like it to be. And you said during your direct testimony that you said status is important. Is that right? Yeah. And you've had a lot of media exposure from your allegations. Some. You've been on The Daily. You've been on Trumpcast. You've been on Condé Nast, right? You've been on all of these places traveling. Yeah, I went on a trip about with my dog, too. You've been on Anderson Cooper. She says, yeah, I had a book come out. It's a good thing to let people know. I have a book out. It's about my life. And you've been on Chris Matthews too, haven't you? The judge says, how much more of this, Tacopina? How much more of this? Are you still going to keep going? He says, Your Honor, yeah, I've got a few more. It's my trial. Says, okay, I'll just mention the last ones, right? AM Joy, you're on that one? Yeah. New York Magazine? Yeah. Nice. Now let's talk about your book, Carroll. She says, well, the book was a dud. The judge cuts in again. Mr. Tacopina, do you have more than 5 or 10 minutes? He says, yeah. Then he says, fine, then we're going to take a break then. Sheesh. So the judge excuses the jury to lunch, and we fast forward through it. We're back courtesy of @innercitypress reporting. Tells us, Judge Kaplan says, all right, Mr. Tacopina, I'm really sick of listening to you. How much more? He says, I don't know, not counting if I have to impeach. He says, I'd say less than an hour. Judge says, okay. Jury comes back in. Now the jury's in, and he says, hey, call up that email. And the judge says, don't you dare do that. So he says, fine, sheesh. Miss Carroll, do you recognize this email? He says, it's a letter to Carroll Martin. And the judge chimes in. Miss Carroll, is this something that you wrote? Now he's going to be laying foundation for the defense. Which is just unbelievable. Tacopina could have done that. Miss Carroll, is this something that you wrote? Tacopina says, okay, thanks, Judge, I guess, for the assist on that one. You said you were in fear you would be harmed after your story. Is that true, Carroll? Yeah. And you wrote to Carroll Martin, your friend. You said you have been walking the streets of New York and you've got nothing but thanks. Counsel for Carroll says, no, that went to her daughter. He says, okay, the daughter. So Carroll says, no, I was not afraid in New York City, but in Orange County, where I live, I was. Now they say, Miss Carroll, are you aware that there is a Law and Order episode that... Objection! Now, Judge Kaplan says, all right, come to the sidebar, everybody. And they get this question in. Tacopina comes back. Are you aware, Miss Carroll, that there is a Law and Order episode from 2012 about an attack in a Bergdorf Goodman fitting room? She says, yeah, I'm aware. You're a fan of Law and Order, aren't you? She says, yes, but not SVU. It's too violent. And Carroll says, it's an astonishing coincidence. Weird. And you didn't tell the writer of the episode about your story? You didn't tell them about Bergdorf attack? No. And you don't blame Elle Magazine for firing you? She says, I understood it, but I was forlorn. They let me go after 27 years. You're aware, though, that Elle Magazine says it was a business decision? She says, yeah, I agree that it was about business. Objection sustained. Tacopina says, it's in her deposition, guys. Oh, okay. He says, so you sent an email to your agent that after... You sent an email to your agent that after Nina Garcia, the editor of Elle, took over, they cut your salary from $10,000 to $5,000 a column. That's how much they pay for columns? Holy moly. One, you were looking to get out of your contract, right? I was looking for other work at The Atlantic. My column used to be in the well of the magazine. The new folks moved it around and they also buried it online. They were mad that you published your book in excerpts in New York Magazine. Is that why they buried you? Yeah. That was Nina Garcia who did that? Yeah. When the President of the United States, says Gene, called me a liar for 3 straight days, my trustworthiness crumbled. And in your email to your agent, you said that Nina Garcia loathed you. Is that right? Carroll says, yeah, she hated me and she loathed me. And so I want to refresh your recollection here, Carroll. Page 187 to 189, just read it. She starts reading it out loud. She's like, oh, great, I'd love to read it. Okay, so on one hot day in a summer day on June, me and he's like, stop. Okay, Judge says, no. This is just to refresh your memory, okay? Tacopina says, it's that L doesn't feel comfortable. And then it's objection, may we approach? Whispered sidebar. They want to go back. They said, let me know you a deposition. Let me show you a deposition from October. Carroll's lawyer objects to hearsay. Judge sustains it. So now we move on to damages. Now, he says, okay, Miss Carroll, Mr. John Johnson was your last relationship, and that was her ex-husband, and she called him a bad racist term. And then apparently he got violent with her, but it wasn't a violence involving sexuality. It was just anger. Tacopina, according to her, alleged. Tacopina says, and you testified that you haven't had sex since what you say happened with Mr. Trump. Is that true? She said, yeah. You were asked, have you had any relationships since? You said no, because Donald Trump attacked me. Is that right? Yeah. I want to show you AQ an exhibit. Judge Kaplan says, you have a hard copy? He says, good news, Your Honor. No objection. They play the audio. So it's audio. He wants it written down too. She says in the audio, maybe I didn't have sex since because I lacked luck. Just wasn't getting lucky out there. Judge says, you didn't play the whole excerpt. So he reads some more. Carroll's not meeting the right person. And he then asks, he says, you're now asking for emotional damages here today from the alleged attack. Is that what you're asking for? Money, damages, emotional money? She says, yeah, I am. But you said, I am fine. I never suffered. That was the public E. Jean, right? That's the public person that you told everybody about, not the private E. Jean. She says, yes. Tacopina says, that came from your book? The judge says, yeah, that's been established, Tacopina. Move on. She says, well, I didn't reveal my whole self. I held something back. It's not all public. I put on the go get 'em face, and I always have. Tacopina says, Miss Carroll, your perception only started to change in 2017. Is that true? She said, well, I was coming to understand some terrible things. Did something else happen in 2017? Oh, yeah. Donald Trump took the Oval Office. She says, I was coming to understand some terrible things out there. Tacopina says, it was the Me Too movement and the Harvey Weinstein stuff? She says, yeah. The judge says, Tacopina, are we getting close already? Can you shut up? I'm tired of listening to you today. Tacopina says, close. He says, define close. This is in front of the jury. Telling them to hurry up. Get on with it. Your case is crap. Are we close? How close? Define close. 10 to 15 minutes. He says, gosh, let's take a break. And they come back. And he scolds the defense. Mr. Tacopina, you said you'd be done by lunch. He says, well, it got a little complicated. I haven't had lunch. Which is hilarious. Great line. Great line. You said you'd be done by lunch. Your Honor, I haven't even eaten yet. He says, you want to keep you hungry, and laughs. your colleague could get you Kansas City ribs. So the jury is now entering. All right, so they're giving each other some grief, and this is just a wild scene because Tacopina is obviously agitated as can be. He filed a doozy of a motion that just blamed the judge for all sorts of egregious rulings. And Kaplan is openly scolding him in this courtroom. So both of these two are professionally at each other's throats, literally. But Kaplan and Tacopina are still joking and jesting with each other because that's just how this works sometimes. And this is actually a good display of, I think, how you can be personally cordial and professionally at each other's throats. And Tacopina is doing a very good job of handling it. I would say exceptional job, because every ruling, one after another, you know, it can really start to break you down, and it can really deviate your entire case. And he is just rolling with it, and he's still joking with the judge. I haven't even had lunch yet, Judge. So the jury re-enters. Carroll's back on the stand. Cross-examination continues. Miss Carroll, you said that on January 31st, you testified that things changed in 2016 for you. Is that true? She said, yeah, I had to get used to seeing Trump everywhere. I want to show you a defense exhibit called CU, puts it up on the screen. The judge says, can we move this along in front of the jury again? They just had a break. The defense is not even allowed to present their case. The judge keeps cutting them off. Tacopina says, Your Honor, we've moved a lot already. We're putting in this Instagram post. Miss Carroll, do you remember this? This is about a hideous man of a New York City walking tour. What is that? She says, oh gosh, New York City has the best walking tours. So I thought of one about hideous men. You'd start at Tiffany's. Women were told not to speak at meetings. And then we'd go to NBC and then to Fox News and then to CBS. Then we'd go to where Studio 54 was. And you posted this picture with the man in the Donald Trump mask. You posted this. Right? You're smiling. You're having a wonderful time. She says it was a very instructive tour. So, okay, Ms. Carroll, I want to talk about one last podcast that you were on. They play the podcast. Ms. Carroll's on the podcast. Hey, Carroll, how's your life been since this is happening? She says, oh, it's been fabulous. Tacopina does the mic drop right there. No further questions. Life's great. What damages, what injury, what harm has accumulated over these years? Nothing. You got a $70,000 a year Substack, and you're doing fabulous. You're on all these podcasts. Everybody loves you. You're going to the cocktail parties with George Conway. Tacopina says no further questions. Judge Kaplan calls in the plaintiff for redirect. Carroll's lawyers are back up. They're going to rehabilitate her, since the judge couldn't do it all for him. Carroll's lawyer says, Miss Carroll, have you had negative moments in your life, I guess? She says, yes, but I've never mentioned them. How do you feel about having found some happiness later in your life? I feel really good about it. That's the goal of all of us in this courtroom, isn't it? She looks at the jury. To find a little bit of happiness. This is a satisfying moment for me. To be here. And her voice breaks. She says, when people ask me how I am, I'm more concerned with them. I don't want to, as they say, unload on them. Now, Miss Carroll, you said your desire for desire was killed. Is that true? I believe in luck. You make your own. I was getting in my own way. I did not flirt. Carroll, did you ever see that Law & Order SVU episode? No. Mr. Tacopina asked you, why didn't you scream? You remember that? Yeah. And Carroll says, I was amazed that a woman would be asked that in 2023. Tacopina says, objection. That's a what? What kind of what? I'm amazed that a woman would be asked that. Objection. The judge says, I'll allow it. Well, that sounds good. Yeah. Anything else you want to say, Miss Carroll, about what an evil patriarchal man he is? Chauvinistic? I'll allow it. Not a big deal. Counsel says, Carroll, why didn't you take your own advice and just call the cops like you wrote about in many of your articles? You said other women should do it. Why didn't you? Donald Trump was very powerful. Women of my age just took our licks and went on. I've looked this up at the national objection. Objection. Okay. They move on. Now, Carroll, how many men are on your hideous men list? 21. And how old are you? Almost 80. Most of the men I've met are not hideous, though. Did you ever have a doubt that Mr. Trump went into your purse? She says, I have no doubt about it. They offer Plaintiff Exhibit 52. The judge receives it. She says, Carroll, what does this email say? It's an email from Steph. What does it say? It says, you're going to get hurt. Carroll's lawyer says, no further questions. Any recross? Tacopina says, yeah. Sure, briefly. Love to. Miss Carroll, are you happy? She says, with overtones. Says, I'm not judging you for not screaming, but for given 4 reasons. The judge says, disregard that. Not an appropriate question and move on. Tacopina says, Carroll, you prepared for this trial today with a list of questions and answers, right? Anticipating you'd be asked why you didn't scream? Objection. The judge sustains it, of course. Miss Carroll, you're excused. Jurors, see you tomorrow at 10 a.m. That is the end of the trial. Day 4. E. Jean Carroll versus Donald Trump. Courtesy of our friend at innercitypress. Make sure you're giving him a follow and supporting his work. He's there on scene, reporting on the day. But a good one. Demands for a mistrial with a nice summary and a list of receipts about some of the bad calls from the judge. And as that motion lands on the judge's desk to be ruled upon, we see another day of trial where the judge is doing much the same. Nothing has changed. We don't expect anything else to either. But this, my friends, is where we are as the day wraps up. Day 4 of the Trump trial. We'll continue to cover. Day 5 will be there tomorrow. We'll see what is in store. And of course, continue to cover. You can join and follow along at home by going to spotlightlawyer.com/Trump to access this full mind map as the prosecution of Donald Trump continues in various parts around the country. We will be assembling it all right here, and we hope you continue to follow. All right, my friends. Now that was it for us on the day. We covered some seriously good ground, but now it's time to hear from you and to see what you have to say about all of this and more. We had some great super chats come in. I'm very appreciative of all the support here today. And hey, we had a nice show today. If you are not already subscribed, we would love it if you subscribed and stuck around. I was looking at the analytics. Over 50% of the people who are here are not subscribed. It blew my mind. I would love it if you subscribed. We don't want to lose contact with you. We'd love to see you here on the next live show. We go live every day. It's a lot of fun, so make sure you're subscribing wherever it is you are joining us so we can see you here on the next one. Now, let's take a look at some of these very nice super chats that came in. And the first one came in from Murph Dog Mandates. Says, am I on auto ignore? I don't think so. You came in loud and clear over here. I don't think so. If anybody has any problems with anything, of course, you can let me know. My email address is robert@spotlightlawyer.com. But thank you for the super chat there, Murph Dog Mandates. I think you're good. I think you're in the chat. Thanks for being here. Tara says, hey, Rob, thanks for the email well wishes. Maybe you could share the video I sent on stream. Waiting for results of my second round of x-rays for collarbone and sternum. Tara, it's so, you've got kind of an active thing going on right now. So what I would do is talk to your lawyer about your active case and talk to them about it. I don't want to interfere with anything that you have active that's going on. Waiting on my second round of x-rays for collarbone and sternum. Yeah, I hope you're doing okay. That was not a good accident. And so I don't want to interfere with that. Definitely talk to your lawyer. Hopefully you've got a personal injury attorney who is working on that case. But yeah, Tara sent a video with an accident in it, and she got kind of rear-ended and kind of sideswiped, and not good. So yeah, Tara, talk to your lawyer about that, right? You have an open, active case. And so prayers and well wishes for Tara, who has suffered an injury, suffered an accident. And we're hoping that you get well soon. Here, this one came in from Jackie Carrion. Says, much love for you. Thank you for giving us this time to share topics. You're the best. God bless you. Well, thank you, Jackie. What a nice thing to say. Thank you for being here with us. I have a ton of fun spending time with you, going through these stories together. I learn a lot as, going through this, and I have a ton of fun with you. So thanks for being here, and God bless you, Jackie Carrion. I appreciate that. Very nice. Jeff says, how, when, and where do these judges get held accountable for the over-the-top ridiculous behavior? You got to impeach them. Congress has to do something about the jurisdictions. There is almost no accountability, right? You can file a judicial complaint. They'll go right into the shredder. What are we going to do? It's pretty amazing. It's pretty shocking, actually, how bad these are. Zulu's here. Says, on a scale of 1 to SCOTUS. Wow, that's a big scale. On a scale of 1 to SCOTUS, refusing to hear Trump's unintentionally crap lawsuits, how illegally is this reptilian enemy judge acting? That came in from Zulu. Is he a reptilian? That would explain a lot. But I don't, so I think you put the illegally here in quote, in asterisks. So I don't think that this judge is doing anything illegal per se, right? The judge has a lot of leeway in trials to admit evidence, to exclude evidence. I think that the judge is being, well, I got to be careful. I don't agree with this judge in what he is doing. And I think Tacopina filed a very substantive motion, a letter motion that is accurate. And I think based in the law, and I think, in my opinion, of this judge's conduct, I don't think it is promoting a sense of impartiality in the court. I don't see that at all. If I was a defense attorney in that courtroom, I would feel the exact same way as Tacopina, and I would be filing the same motions. Is it illegal? Like, can you report this to a prosecutor and charge this judge with a crime? No, it's his courtroom. He's allowed to do these things. But it doesn't remind me of justice at all. I mean, it feels like this whole thing is a setup, essentially. So, it's a good question. I didn't know that he was a reptilian. I'd call it on a scale of 1 to SCOTUS. I'd call it on a scale of 1 to SCOTUS. It's pretty high. I don't know. I think I'd call it somewhere between, I'd say it's above a Derek Chauvin and below a Ghislaine Maxwell. How's that for you, Zulu? Take that for what it's worth. I don't know if that even makes sense, but that's what I've got. We had, hey, another one on Rumble, and thank you everybody on YouTube who sent in those very nice super chats. I appreciate everybody for sending those in. And good to see you, Zulu. Good to see you, Zulu. We had another one from Jane Catherine Berry. What's up, Jane? Says, E. comes out of Helen Gurley Brown Cosmo Girl School. She gave advice to single women on how to use their sexuality to trap a rich husband. So I have zero respect for her career. Wow, that is an interesting Rumble rant. I did not know that one. That one came from Jane Catherine Berry, which is just awesome. What a good comment. Here's what that looks like on the screen. E. Jean comes out of Helen Gurley Brown, Cosmo Girl School. Gave advice to single women. I have zero respect for her career. Very interesting. Well, she does hate men, and, I don't know what that's all about. I think we had a couple others. We did! Alan Harkin! Wow, amazing. Good to see you, Alan. What's up, Alan? Says, awesome show. I won't lie to you. I'm an enormous Trump supporter, and it's painful listening to these depositions at times. No offense to you, of course. You do a great job informing and educating. Yeah, I guess I don't know what part of it is painful. Are you finding that it's painful to listen, like you're hearing some things about Trump that are painful to you? Or is it more that you're hearing the injustice, which I would suspect it's this. You're hearing the injustices and the attempts that Trump is making to defend himself are flying away, or just not being considered. And I agree with you. It's a little bit deflating, right? Every time we come on here, it's the same judges with the same pattern, the same biases, the same arguments are being made, and Trump feels like he's not being given a fair shake. It is deflating, but it's not always going to be like that. It will not always be like this. There will be things that change as a result of this, because by allowing these types of proceedings to continue, they are wrecking their own legitimacy. They used to be able to do a lot of this stuff under, behind closed doors and in the dark of night, but we're covering a lot of it. And I think a lot of people are starting to recognize that all of these Trump accusations, they sound like the boy who continues to cry wolf over and over and over again. And eventually people just stop believing them. The convictions will come out. Oh, Donald Trump is convicted of insurrection. Everybody's going to go, who cares? Who cares? Your institutions are illegitimate. Look what you have done. Because the trials are going to be exposed. They think that they're going to mean something, but they are wrecking their own institutions. They don't even know it. Sheesh. All right. It's good to see you, Alan. Thank you, Alan, for the very generous super chat as well. And I suspect that we're probably in sync on that one. Hey, we had another one from Andres Burzins, is a member now over on Rumble, which is awesome. We have members now on Rumble. Woo! Membership, baby. Good to see you, Andres Burzins. And that was over on Rumble. We got some amazing Rumble chat. Super fun. Sully's in the house. We got Nick Danger, Dog Digger is in the house. Yeah, and Sedona says sunlight. Sunlight is the best disinfectant. It is. The more we can shine the spotlight down upon this, right? The more we can expose what's going on inside these courtrooms. These federal courts are all closed down. They don't want us to talk about these things. They don't want us to see and open this up and peer inside. But we are. And it is going to expose a lot of the nefariousness, and hopefully the sunlight helps correct some of the problem. But okay, my friends, that was our amazing generosity over from Rumble. And I think I may have missed, if you're a member, let's see here. Gosh. Yes, we did. Hey, thank you. And so thank you to the mods who captured all of these for us. Very appreciative of this. Mark Austin, welcome to the community. And Jenny B has been a member, says they will never convict Trump of anything, period. Says Jenny B. They're going to try. They're definitely going to try. No doubt about that. They're definitely going to try. And I think they're just warming up. We're going to be looking at Georgia, July through September, and then we'll have special counsel, 2 different investigations that are working on. So I think more will be revealed. Convictions is another story. Charges, I think there will be more to come. Prairie Pond is here. What's up, Prairie? Says, awesome. We got Tara Rayner. And I think this one came in from Jeff. Yeah, this one came in from Jeff. How and when, oh, we got that one. I think we missed one from, I I apologize if I missed one. Maybe we got it. All right, but look at this. All right, look at this. From John McGarvey. Holy moly, look at all of these new faces we're going to have. in the house. From John McGarvey, 50 new members. We got Mark, Rose, FaZe, Rose, Stinta, Luke, another one from Tommy, Lau, Lily, Sir Don't Trip, Dark Energies here, Chosen One. We got Thuperman. Thuperman is joining us. We've got Cameron, Arena, Florence, Loaded, Poem, Michael, Juanita. We've got Nathar, Marms, BJ, Chadwick in the house, Corey, Jesse, that girl's here. What's up? We got Joshua, Valerie, Donna, Michael, Gnome, woo, Tripos. We got Drea, Gustav, Da Freak. 50 membership, says Frezio. Holy awesome. Amazing. Holy F got one. Samantha's in the house. Oh man, it's going to be, it just keeps going. We got C. Warren, Nunya, Auntie, Dr. Mimo, Frank, Steve Lee, Benjamin, Jane, Patriot Chick, and Fish Finder, man. Whoo! All coming in to our new members only community on YouTube, which is just awesome. Thank you, John. And welcome to everybody who joined in. Don't forget to grab the Telegram link, which is in the community post section, because we do member only streams, and we'll be here live tomorrow morning to hit the headlines. We cover all the additional things that we can't get to here on the show because we've got trial. I mean, tomorrow we'll have another full day of trial, but there's a lot of other stories to cover. And so we do that on our members with YouTube and of course over at watchingthewatchers.locals.com. And so I saw another super chat come in here from our friend Captain Flatastic. Pull this one up on the screen. Says, can we class action lawsuit sue the DOJ for dereliction of duty? Thanks for a great show tonight. Thank you, Captain. Thanks for being here. It's a great question. Unfortunately, the answer is no. There's a concept called standing, and essentially it says that you can't bring a lawsuit against a government when a better course of action would be to just vote and change the government, right? They say that's the appropriate mechanism. If you don't like the DOJ, vote for better leaders. And we don't have that. Adam M says, read my member chat. I don't see it, Adam M. That's the one I was looking for, Adam. Adam, what did you say? What did you say? I didn't see it. So just say it again and I'll just read it now. Because my chat disappears. It only goes up so far and then it disappears. It falls off so I can't see it. But Adam's a member. And we love Adam. Thank you, Adam, for being here. He doesn't remember what he said either. Okay, well, we'll get you on the next one. If it comes back to you, let me know tomorrow and we'll hit it on tomorrow's show. He said it was so funny, though. I know it was. I'm sure it was just great. It was probably like 10 out of 10. It'll come back to you. And then, of course, we'll hit it tomorrow. All right. And that is it for us, my friends, on the day. We are going over to watchingthewatchers.locals for our after party, and we would love to see you there. All of our YouTube members, grab the Telegram link because that's where we're going to see you in the Telegram group right after the show. It's if you go on the YouTube app, go to community, and you'll scroll down. You'll find the link. Also, don't forget to get your greens over at fieldofgreens.com, and you can use code Robert to save. And I got a message. Check the chat. Here it is. This is the one. This is the one. Thank you for digging that out. I think this came in from Donut Mind Me. Yes, thank you, Donut. He said, this is the one. This came in from Adam. He says, if the finger's too short to fix, you must acquit. I see where you're going with that one from there. If the finger's too short to fix, you must acquit. That's an old OJ thing. It was pretty funny. I'm not going to explain why that's funny, though. Thank you for that, Adam M. I'm glad we caught it. And thanks for digging it up for us, Donut Mind Me. I appreciate that, my man. All right. And so don't forget to go to fieldofgreens.com so you can get your real organic superfood and be healthy and well. Get your daily servings of fruits and vegetables. The vegetables want to be eaten. That's why they're here. They pop out of the ground so excited to be here. Just eat them. All right. So fieldofgreens.com, save with code Robert. If you want to get the Mindmap software, the tool that I use, it's awesome. Go to spotlightlawyer.com/mindmap. You can put animated GIFs and or GIFs in there. You can put videos. You can put YouTubes in there. Ton of fun. spotlightlawyer.com youtube.com/mindmap. Thank you to the mods who mod down the fort for us. Let's start at the bottom today. We've got here Geegum Geegum, who's our meme smith, Sleepy Dog Lee. Shout outs to Donut Mind Me. Thank you for all of the clips today. Dog Digger, we've got Janek, we've got John Allen, Zach Nichols, Geomancy, Zulu's in the house, along with our friend Ronnie, who I think is name changed on that one. Playing Hooky, Just Cause, K-Bean, and our boy Vanticus Prime. I think it's game night over there since it's Monday. But that, my friends, is it for us on the day. We are going over to watchingthewatchers.locals.com for our after party. I hope to see you there. But if not, we'll be back here tomorrow to do it all again. Members in the morning, we'll see you here for our headlines show. Don't forget that. But otherwise, we will be back here to do it all again. It's going to be day 5 of Trump trial. We'll see if the Proud Boys have a verdict in for us. We've got some Hunter Biden news. May hit that tomorrow. He had court today. Might hit that in the morning for our members. But that is it for us. I hope you have a beautiful, beautiful evening. You sleep very well. I'll see you right back here tomorrow so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Have a beautiful evening, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.